Welcome. Thank you for tuning into Community Chat. My name is Kevin Tachi. Joining us today for this timely chat is a gentleman who you're no stranger to. His name is Chris DiOrio. He is an attorney, and he specializes in several areas of the law that includes civil rights, human rights. Welcome back to the show.
Thank you very much, Kevin. Good to be here.
Is it fair to say, this is my opening softball question to you, that you are very well studied when it comes to constitutional law and the inner workings of the federal government?
I've been teaching constitutional law locally for about 11 years now. And as a person who works in the civil rights field, as part of my practice, you've got to know what the book says in order for you to be able to talk about it. So you can say that I'm well versed in the area, yes.
So the primary focus of our discussion is to take a look at the actions of the Supreme Court, who actually recently overturned the 1973 landmark decision known as Roe versus Wade.
Correct.
That ruled that the Constitution of the United States generally protects a woman's liberty to have an abortion. For those who have no idea actually what that means or what this decision means, maybe they don't fully understand it. What does it mean?
Sure. Roe is a 1973 decision, as you said, that enshrined a woman's right to choose to terminate her pregnancy. The decision itself was an oddly written decision, not necessarily the best piece of judicial craftsmanship, but the theory behind it. Sometimes something you get there by difficult means, but the result is what's important. And it piggybacked off a previous case, Griswold versus Connecticut from 1965, that enshrined a right to privacy in general, related to issues related to contraception and things of that nature. From Griswold, we then get Roe. Since 1973, there has been an onslaught of cases that have attempted to limit Roe, specifically in 1992, in the case that really is the solid precedent that the folks on the court were going after, Planned Parenthood versus Casey, where a plurality protected Roe and created what they referred to as the undue burden standard, that laws that are created that deal with a woman's right to choose cannot create an undue burden on that right. And that's what Casey said in upholding Roe. Roe was written with what they refer to as a trimester system that acknowledged two separate rights. One, that a woman had a right to choose, but secondly, that a state had a right to protect life. The issue then became, where does the state's interest begin and where does the woman's interest end? Or at least, where can the state begin to encroach? And that's what Roe did. Roe had a trimester system that said for the first trimester, the first 3 months of a woman's pregnancy, no laws at all can affect the woman's right to choose. And then when you get to months 4 through 6, then the state can begin to intrude, and from 6 on, the state can ban it entirely. Casey removed that trimester system per se, and then said a woman has a right to choose up to the point of viability. You know, the look on your face is where the confusion comes, and where does viability begin and end? It's a scientific question, but also a moral question, and that's what in the majority opinion in Dobbs just recently referred to this complex issue and this nature of morality versus science, and where do we begin to draw the line in terms of viability, or if we have a viability question at all.
I think the next two questions would be, first,
okay,
what effect will it have nationally?
The Dobbs decision by the Supreme Court, a 5-4 decision that stated that the Constitution itself does not protect abortion. They took great pains in the majority decision to try to limit it, to just say that there is no constitutional right to abortion, that it is not protected as a fundamental right, as is your right to free speech, your right to be free from unreasonable search and seizure, all of those things that we believe as fundamental, that abortion was not mentioned as something that was protected fundamentally. So they now say that Roe is no longer good law. That's what happens when you overturn something. You can limit a case or limit a standard by taking little pieces out of it. They outright said Roe is no longer good law. What that means is now it throws everything both into a federal tizzy and to a states' rights question. Because now, by eliminating Roe, Now individual states are left to determine whether or not they are going to codify the right to choose into law, or whether they are going to go the complete opposite direction and ban it entirely, which many states have either done, had ready to go with what were referred to as trigger laws that said inside the context of the law that if Roe is ever overturned, this law will kick in within 15 or 30 days after the case is decided. Or now a number of state legislatures are going back to the drawing board and either recrafting new laws to restrict a woman's right to choose, or resurrecting old laws. Missouri, Mississippi, the case where the state where Dobbs is, had imposed a 15-week ban on a woman's right to choose, saying that anything that occurs after 15 weeks we can restrict. Mississippi wins the Supreme Court case and then says, well, we have this law, but now we're going to go back to an older law that says that, that we already had on the books, that says that we're going to ban abortion entirely, except in the cases of rape and to save the life of the mother. So now it is both a federal issue and a state's question.
And the overturning of this means, and you just mentioned a couple of things, is that in the case of rape or in case of other instances, abortion basically is, in those states with the trigger laws, is automatically banned.
It depends on the individual state. Again,
right, and the language and the legislation itself. Yes.
It would say it inside. There would be certain exceptions written in, but a number of the states that we're talking about don't have any restrictions at all, or any exceptions at all. Excuse me. Where, regardless of whether it is rape or incest or to save the life of the mother or any other,
right.
Sometimes these types of procedures, abortive procedures, taken later on in the pregnancy, are meant to resolve issues that could, help the mother, eclampsia and things of that nature that, might result, or fetal abnormalities that, the fetus itself is incompatible with life and is causing harm to the mother, but, they still won't allow it because you have to get, under the view of some of these state legislatures, it's life, we're going to give it a chance, and if it doesn't happen, then so be it. But, that's that.
Let's talk about here in the Commonwealth.
Sure.
What could this decision change? What knee-jerk reactions could we see from this decision, this ruling?
Massachusetts is one of the 24 states right now that have in one way or another protected or preserved a woman's right to choose. Massachusetts in 2019 and 2020 codified the woman's right to choose with the Roe Act. Basically preserving a woman's right to choose up to 24 weeks. And at that point, they can begin to restrict it. But even after 24 weeks, a woman has the right to choose to terminate a pregnancy if there is a physical reason attested to by a doctor, or, just as importantly, an emotional or mental justification for doing that. If this would cause emotional distress to continue the pregnancy, a woman's allowed to do it. The Roe Act also scaled back the ability for folks to get reproductive care from 18 to 16. You no longer need to go, if you're under the age of 18 prior to 2019, you would need to go get a court order in order to have a reproductive procedure done. Now it's back to 16. Just recently, I applaud Governor Baker for doing this and having the guts to do it, considering the folks that are on the other side in his party. The Dobbs decision was crafted at 10:10 a.m. and was released to the public at 10:10 a.m. At 10:25 a.m., Governor Baker signed a series of executive orders and implored the Massachusetts House and on Beacon Hill to engage in a number of legislative acts that would further protect a woman's right to choose, not just a woman's right, but also providers here in the state, and that's tremendously important. Because we're one of these states that has protected this right to choose, people are going to come from other states, and we're talking about knee-jerk reactions. There are a lot of people that are going to come into Massachusetts to get this kind of care. From the woman's right to choose is well protected from Maine all the way to Virginia. With the exception of New Hampshire that tried to do something with fetal ultrasounds and things of that nature, a woman's right to choose is protected in all of the New England states, into New York, New Jersey, Pennsylvania, and down into Virginia. Right at the border of Virginia, that's where it all stops. But there will be people coming in. And so there's these states that are not just prohibiting abortions, but also indicating that they will prosecute individuals who engage in them, like Texas, like Mississippi, and treat them as felons, and some would actually charge them as murderers. what the Mass House did was attempt to codify a number of protections for healthcare providers, pharmacists as well, because if you're going to try to make Plan B and other types of abortive contraceptive pills illegal, pharmacies and pharmacists are also protected from being prosecuted by other states. Law enforcement agencies in the Commonwealth under this new law would be prohibited from cooperating with other law enforcement or investigative agencies from states seeking to prosecute Massachusetts folks in state. It's a great deal of protection that's being provided, and that's what we're doing in our knee-jerk reaction. Ours is to protect these people because we believe in the right to choose here.
If folks are tuning in, we are having a conversation with Chris DiOrio, not only an attorney, but also as well studied in constitutional law. Interesting having this conversation right around the time of America's birthday, but I couldn't have thought of a better time in order to have this conversation. A couple more questions in our conversation here. Sure. And legislatively, can the Congress, can the president create legislation or have executive orders put in place to supersede the decision moving forward, whether it's with this president, with this body of Congress, or future?
Can the president do things? No. He can advise, with an executive order regarding the potential prosecution, but the federal government does not prosecute folks for these things, so it's not an issue that the DOJ would be involved in. Can Congress do something? They have the power to do it. In fact, the Women's Protection Act was something that has been passed in the House of Representatives for a number of sessions. It won't make it through the Senate. And that's the problem. Because the filibuster exists right now, you would need 60 senators to say that we're going to allow this we're going to vote to cloture for what's referred to as cloture and allow for the vote to be taken so that you can get a majority vote. That's the mistake that people make when they talk about the filibuster. You can't just stop the law from happening. What you're stopping is discussion on the law. And if you're not going to debate it, then you can't have a vote on it. That's the rules in the Senate. And we have maybe, if you get all of the Democrats on board right now in this session, that would be 50. Senator Collins from Maine, Senator Murkowski from Alaska have both indicated that they are in favor of women's right to choose. They are right now working with a couple of Democratic senators to try to craft some sort of legislation that might be passable in the Senate. It's unlikely, however, that you would be able to pull another. I don't know where the other 8 senators would come from that would allow for the bypassing the filibuster. So can they do it? Yes. Will they do it? Extremely unlikely in this iteration of the Senate, unless after the midterms. We have a couple of more senators. If Democrats hold the Senate and pick up a couple of extra seats, perhaps they get enough senators to vote to carve out for the filibuster specifically to deal with this, or to eliminate the filibuster entirely, which would allow for a vote to take place. But again, that would remain for after November.
We have a final question, and I feel that this one probably has there's depth to it, because first and foremost, we're talking about what ifs, and usually those are difficult to talk about. But there have already been concerns voiced by pundits that the Supreme Court could look to go after other landmark decisions. Yeah. Have you heard the same thing? And is there any concerns that there are other things that could be in the works?
There are concerns, obviously, and if you look at the rationale of the majority decision, that's part of where it comes from. Justice Alito, in writing the majority decision, said that due process is what we're talking about when we're dealing with a woman's right to choose, and that because due process is enshrined in the Constitution itself, both in the Fifth Amendment and the 14th Amendment. But some people believe that due process simply means that you have to have a process in place before you can take someone's life or liberty away. What he referred to, though, is saying that we will only protect these fundamental rights if they have been traditionally enshrined in America's history, or if they're protected somewhere else in the Constitution. And in looking at the Constitution itself, abortion is not mentioned. Women are also not mentioned, nor is any other things. But slavery is. That's a story for another day. But so he's saying that that abortion is not protected in the Constitution, period. But he also took great pains to say, the majority, that this rationale should not be meant to address other issues where due process might exist. Justice Clarence Thomas, in a dissenting opinion, however, it sort of pulled the curtain back on the great and powerful laws as far as the ideology on the court is concerned, in indicating that he believes that substantive due process does not exist, and that we should then go in the future and look at cases where substantive due process was utilized, specifically referring to Lawrence versus Texas, a case dealing with same-sex coupling and whether you're allowed to criminalize people who are involved in same-sex relationships. Loving versus Virginia, which he didn't mention for, I'm sure, reasons close to his own heart, but dealing with the right to marry someone outside of your own race. The Obergefell versus Hodges decision, which dealt with enshrining the right to same-sex marriage, otherwise known as marriage. But all of these things were decided on substantive due process grounds. And if, as Justice Thomas surmised, and as the logic from the majority decision opened up the door to, if we only protect those rights that are fundamental to our previous history, or if we don't agree that due process exists at all substantively, then there was no traditional right to a same-sex marriage. There was no traditional right to an interracial marriage. There was no right to same-sex Congress and relationships and things of that nature. All of those things are potentially at risk. Those things could go out the door with this current rationale. That's the spreading out of what Dobbs and its logic could do in the future, especially if we get what Justice Thomas wants to happen.
Well, I guess it remains to be seen as to whether these will be next for the American public to keep an eye on and anticipate a decision being handed down. We want to thank you for at least giving us the breakdown as to the recent decision by the Supreme Court, and also sharing your expertise with the audience.
Kevin, thank you very much for having me.
And we want to thank you for tuning into a program like this. Again, the idea is to have conversation, share ideas, things that are going on in and around the community and beyond. Until next time, have yourself a great day.